Good afternoon, everyone. My name is Shiping Shen, at University of Law in the UK. It is my honor to welcome you as an assistant researcher of the Nova Center on Business, Human Rights, and the Environment to the first annual conference on business and human rights. Our panel will focus on corporate due diligence and the digital transformation. This is the second section of our annual conference on business, human rights, and sustainability. We wanted to thank you, our sponsors, the Portuguese Chamber of Commerce and Industry, PLMJ Law Firm, as well as our partners, CEDIS and Nova for the Globe, for their support. Now it's my honor, a pleasure to introduce you, our chair, Eleanor Lumsden. She is a California attorney, law professor, and founder of a consulting firm bearing her name. Eleanor, thank you so much for accepting our invitation. Now the floor is yours.
Thank you, Shen, for that introduction, that lovely introduction. First, I'd love to welcome all of you. Thank you for joining us for this panel. I'd also like to make a special thank you to our student team. That's Shen, Dusu, and Rafaela, as well as our director, Claire, for having the brains and the initiative to put this event together and for inviting me. We are thrilled to welcome this very special panel of experts to talk to us today about corporate due diligence and the digital transformation. I will say that my interest in this work comes from research that I was doing some years back in my native Jamaica, in which I was looking at mobile technology and how that technology could be used to increase financial access for persons who were banked or underbanked. And in the process of doing that research, I was struck by the balance between innovation and regulation and how tipping the balance too far in either direction could have consequences. So I'm still interested in that balance. And I think that our panel today will be talking about those intersections and more. So without further ado, I'd like to introduce our first panelist today is Isabel Ebert. Isabel Ebert is a senior research fellow at the Institute for Business Ethics at the University of St. Gallen and holds a PhD in organizational studies. Her PhD focused on digital companies' managerial response process to data disclosure requests by governments. She also serves as a strategic advisor to the United Nations on business and human rights in the technology sector, the B-Tech project. Isabel, thank you for joining us. Given your research around business ethics and human rights, I'm excited to talk to you. I will say to everyone else that Isabel is here with us for a short time. She has to leave a little bit early. So while you hear her speaking, if you have questions for her, please send them in immediately in the chat or the question box so that we can see them and she can hopefully respond. Okay, Isabel, I'm going to turn to you. I'm going to ask you to frame our discussion for us. What does it mean to talk about due diligence in the context of human rights? And what precisely do the UN's guiding principles on business and human rights mean for corporations in the EU?
Thank you, Eleanor. And first of all, I would like to thank the organizers for bringing us all together today, and also the student team, and also you, Eleanor, for moderating today's session. So as I think also my fellow panelists will articulate later, when you speak about due diligence in a more general sense, the term is usually used to describe an assessment of risk to the business. And in line with the UN guiding principles on business and human rights, due diligence relates to human rights due diligence. And here it's really about the risk to people that are in focus when you are assessing the impacts. And those impacts are business impacts on human rights stemming from or being connected to the activities of the business. And the guiding principles follow a value chain approach. So they call for all businesses to carry out human rights due diligence to identify, prevent, and mitigate adverse impacts on human rights. And usually the process is clustered into 4 steps, although they're sort of different interpretation, but they all sort of cover the same thing. It starts with the identification and assessment of the impacts to understand the nature and extent of human rights risks. Secondly, it means acting to prevent and mitigate risks to people. And that also includes integrating those risk management processes into internal functions and across the respective units. Thirdly, companies should track the effectiveness of these risk mitigation systems over time, also make sure that they respond to risks that might be emerging while the due diligence process is going on. And then very importantly, they should also fourthly communicate appropriately about the performances on those identified risks, and then try to sort of have a due diligence process as an ongoing exercise that then can also serve as a learning experience inside the company. So you might, while you're doing the impact assessment, you might discover things that you would have really not anticipated. In particular in the technology sector, as you might roll out certain technologies, you might discover unintended consequences that you were not able to project ex ante. And so that's why also due diligence really has that sort of ongoing nature that I would like to emphasize. So the principles weren't sort of made up in a void. There was a several year long process, a global consultation process where business participated, civil society participated, trade unions, and then they all endorsed the sort of guiding principles that we're using since 10 years. And when it comes to the conduct of tech companies in the European Union, it really follows that sort of same approach. So the UNGPs are a global framework. They're of course by that also valid in the EU. Some of you might have followed this ongoing debate on the EU mandatory due diligence law that would then also, besides human rights, encompass environmental due diligence. And so the way we should think about the guiding principles is really that they are sort of a global normative framework with a really strong political foundation, and sort of they have a really sort of pragmatic approach. It's not that we would assume that businesses can never harm human rights, but that they have the obligation to really responsibly identify, prevent, and mitigate those adverse impacts that might occur, but at least you should manage them. And of course, the ideal goal would be that businesses do no harm. So that's what we're sort of striving towards. And since those 10 years, so the uptake by business is quite significant. You can also see that most of the big tech companies now have a human rights policy in place. The other question is then, how does that trickle down to actual practice? And I think there are some differences. And we are basically in that UN project also working on that aspect, on implementing the guiding principles in the tech sector. So the BTech project was really launched in order to translate the cross-sectoral guiding principles to the management practices of the tech industry. And we've come out with guidance on how companies can respect human rights, and in particular on tech, and how they can be also incentivized to do so by the state, either through regulation, but also through sort of incentivizing mechanisms, export credits for companies that demonstrate that they have better processes in place than others might have. So it's really that sort of belief to cultivate the knowledge about human rights as a sort of universal baseline when you're doing business. And again, in order not to act in a void, we have also a community of practice where we are bringing together sort of the big players in the tech industry and speak about the human rights due diligence processes, what's going well, what's not going so well, how that could be improved. And the ultimate goal is then really to translate the guiding principles to the specific challenges of the tech industry. I'll post the website in the chat. We've recently also published some outputs where we reflect on the current state of human rights due diligence, in particular deriving from this conversation with tech business. So that would be sort of my reflections on the difference between the terminology around due diligence in comparison to the sort of a standard definition, but I'd be happy to hear also what others think, how that connects to the sort of general due diligence terminologies.
Okay, thank you, Isabel. I really appreciated those remarks. And there were a couple of things that you said about that I picked up on unintended consequences and sort of implementation. So my next question to you is, what are the main challenges that you can see for the tech sector specifically in terms of them contributing to a more responsible and rights respecting environment, whether on the internet or elsewhere?
Yeah, thanks. So, I mean, I think today is actually, or maybe yesterday, it was interesting that you have seen maybe what Apple announced that it's going to sue NSO Group. So you see that sort of within the tech industry, there's also that sort of battle who appears as the more privacy friendly one. In a nutshell, I would say we have seen that in shaping the digital transformation, the private sector is obviously the one that is sort of the key actor. And in particular, when it comes to global internet governance, and that really relates to where the guiding principles come from. They were adopted because also the UN sort of realized that the power of states is doesn't equal the power that global business have. So it's sort of really closing that governance gap of the power that also today big tech has, and bringing them into the conversation about what type of economy we want to live in. And in that regard, it's a bit concerning that some of the tech companies really continue to sort of dodge and sidestep their responsibility as agents, because we know that humanity is really dependent on that type of connectivity structures, but also communication structures that tech offers. And at the same time, while we're so dependent, it's really complex to find an inclusive way of sort of governing those structures without cutting access to freedom of expression, or not really using those potentials that innovation can bring, in particular when you think about remote communities or all the types of solution of AI that might be coming up in the health sector, right? At the same time, what's one of the key issues why it's so hard to govern the tech space is because also the speed of the adverse impacts might spread so quickly that it's really hard to sort of get the devil back into the box once the adverse impact has been unleashed. I think we saw this in particular with incitement to violence on social media platforms. At the same time, I was speaking about connectivity, and again, there also telecommunications companies, of course, sort of the ones that we work with, and they're so vital for providing connectivity and really connecting the social layer with the infrastructural layer, and then sort of providing the services that the digital services that many other platforms are offering online. And when we then have at the same time witness this global increase in network shutdowns, it's sort of where maybe the state interests and corporate interests sometimes really collide, where some governments have a keen interest on cutting access because they want to maintain their power, but the citizens actually would like to continue to mobilize and exchange ideas how they would like to live together. So again, I think that the role of the private sector in shaping our digital transformation is essential. It's absolutely vital. They need to be in the conversation, but it needs to be clear on what type of minimum consensus they're operating. And from our point of view, it's really the UN guiding principles. It's about not doing harm and really managing the adverse impacts stemming from the business conduct. So yeah, thanks very much.
Thank you, Isabel. We really appreciate those comments. Just as a reminder, before we move on to the next panelist, everyone, there's a button at the bottom of your screen that is for Q&A. So if you would like to submit your questions, and particularly as we have Isabel just until 4:30, for Isabel or others, please feel free to write those questions in, and we'll be looking at those questions as we move along. Okay, so our next panelist is David Jargiello. Welcome, David. David is a partner at the VLP Law Group, VLP Group LLP, and he's the chair of its Professional Responsibility and Risk Management Practice Group. He also serves as the firm's general counsel. David is a business transactional lawyer with more than 30 years of experience in San Francisco and Silicon Valley, primarily representing venture capital funds, professional services firms, and legal technology companies in complex corporate finance, corporate securities, fiduciary duty, and risk management matters. David and I also happen to be colleagues at GGU School of Law, where he teaches. He also teaches at UC Berkeley. It's a pleasure to welcome you, David.
Thank you for having me.
Yes. So David, the first question that I have for you is that the words when you hear due diligence, it maybe triggers some different thoughts or feelings in the US. And so I'd love to hear what you have to tell us about the different technical or colloquial meanings of due diligence in the US. And, you know, given what Isabel's talked about in terms of the meaning in the EU, any differences there?
Yeah, it's an excellent question. So to a business lawyer or transactional lawyer or securities lawyer in the US, the term due diligence would immediately have a very different connotation to it. That doesn't mean the other doesn't, but I think Isabel framed it exactly right at the beginning of her comments, which is in the US, the notion of due diligence, generally speaking, the first connotation that comes to mind, I think, for most transactional lawyers would be the outward-looking, what I think of as sort of the outward-looking due diligence. Its sources originally to a provision in the United States federal securities laws, which states that there's a variety of causes of actions people can bring if they purchase securities pursuant to a misleading offering circular. One of the defenses to such a claim brought by a plaintiff is, I conducted a reasonable investigation as to the facts stated in that offering circular. That reasonable investigation defense is commonly known, colloquially known in US securities laws as the due diligence defense. And over time, that notion of a due diligence defense has morphed in what I think of as it's morphed into a verb. And it's morphed into a concept, again, of this outward-looking connotation of, as a principal to a business transaction, you have looked at the things that need to be looked at, reasonably need to be looked at, so that you have, with some objectively reasonable level of scrutiny, such that you are doing whatever you think you are doing in that transaction. And so the word, again, has sort of become a verb in a sense of, due diligence on individuals, due diligence on the business, due diligence on the financials, far, far beyond the stretch of the securities laws. But the core thing there is, I think there is a deep connotation on the one hand of, some sort of objectively reasonable investigation, as Isabel said, to assess the risk to the business enterprise. The converse also exists, and that is what is, I think, the focus of what we're talking about here, which is not only are you looking at what others are doing and how that risk might splash back on you, but what are you doing as a business enterprise that might create risk to others. And that's certainly the fundamental issue here. Writ large, the notion of due diligence in this latter context is, looking at what your business operations in whatever way, the way you run your business, the way you run your supply chains, the way you manufacture your products, the way you recycle your products, or whatever it might be, what impacts do those have on the community in which you operate at many different levels, levels of human rights, industrial employee relations, environmental impacts, consumer protection issues, and that does exist in the U.S. as well. So there are those two different connotations.
Wonderful, thank you, David. So staying with the business lawyers, I'm going to move on to Pedro Lomba. Pedro, I'm going to ask you to speak to sort of the similar question as I asked David, but for Portugal. But first, Pedro is a partner at PLMJ and the head of technology, media, and telecommunications. As a lawyer, arbitrator, and policy advisor, he specializes in information technology and communications law, media law, internet law, collaborative and digital platforms regulation, mobility law, consumer law, and data protection. He has a PhD in constitutional and communications law, and he is a professor of law at the Faculty of Law of Lisbon. Pedro, it's lovely to have you with us. I welcome you to the floor. My question to you is, as a practicing lawyer, business lawyer here in Portugal, what does it mean to you to exercise corporate due diligence in the context of digital transformation? What comes up for you when we say those words? Pedro, you're on mute.
I was just saying thank you for having me. Well, as David said, corporate due diligence here in Europe, I would say, also has a double connotation. And it is true that increasingly it is the impact of corporations in the way corporations intervene and act, the kinds of harms of their practices in human rights. I would say that this perspective tends to essentially prevail. I would, in this sense, emphasize how corporate due diligence, in this sense, is pretty much the conversation we had before about corporate social responsibility, the whole idea that companies also take responsibilities for their impacts on society. They need to ensure that social, environmental, ethical, consumer concerns are actually incorporated in their business operations and strategies. When we discuss particularly the case of digital companies, we do have some interesting additional remarks to make because, well, first of all, everything is beginning now. We're actually witnessing the transformation of the internet into a universe of platforms. There's a really what some call the platformization of the law. So there's real a law of platforms, and many popular platforms, as we know, are now global corporate actors. So many popular platforms expose and use content to users worldwide. And so the corporate due diligence, the kind of challenges that the topic creates for this new environment is what exactly means in this context of global digital powers, global private powers, to actually ensure those human rights standards. What exactly does that mean? So we haven't been, can also discuss how this can be accomplished in practice, but that's something obviously new, the discussion, and the discussion is, of course, in legal terms, how are, of course, what does it mean to protect human rights or fundamental rights in this context? What does it mean to protect what does it mean to actually bind digital powers to human rights, to fundamental rights? And that includes, includes not only traditional rights, and let's say freedom of expression as a traditional right, but also, new rights. And we know that the whole discussion between automation and artificial intelligence and algorithms and fundamental rights is now booming, and is actually now starting. So it's a discussion then about not only how these digital private powers actually respect fundamental rights, and how fundamental rights remedies can be invoked against them. This is something that, in the past 5 to 7 years, there's now an interesting case law in the main European courts about this, main national courts about this, but also, new rights, which is also something new. There are new rights, there are new fundamental rights, there are new rights in the context of the algorithmic society, there are new rights in the context of the platform economy, the data economy. So the content of the subject, corporate human rights due diligence, it's not closed. So I would say the first thing we should do is what rights are we actually talking about? What is the impact of a certain corporation, certain company? What is the perimeter of rights that can be potentially affected? In some cases, we would have, an environmental type of rights. In other situations, other rights will necessarily appear. So I would make these remarks at the beginning. Of course, we do have another issue here, and the other issue here is, how are we supposed to balance the rights of, and specifically these new digital rights of individuals, these new human rights, with the rights of the companies themselves? This is another difficult topic, and I think it's important now to address, because these topics are not obvious. Just to give you an example, let's say just to close this intervention, let's say we need to assess whether a certain corporation is actually compliant with data protection laws. That's easy in one sense. We can actually list the commitments, list the policies, list how this is actually implemented in the context of that corporation. But in many occasions, there are balances that need to be made, and those balances are not difficult. So I find it very difficult to say that, company A or company B is, fully compliant, and company, I think this is a much more complex discussion.
You're right, Pedro. It is more complex, and I look forward to digging into sort of some practicalities with you, David, and the other panelists soon. Let's move on to the digital transformation part of our topic. I'm going to turn to Valerie Conde. Valerie, welcome. Valerie is a serial entrepreneur and an expert in the startup ecosystem with 15 years of experience in the areas of finance and technology. I will insert here that Valerie and I also are community members together in the fintech house here in Lisbon. So it's great to see my neighbor. Oops. Okay. Valerie currently heads international growth at Pleo, a Danish fintech scale-up backed by prominent VC investors such as Bain Capital, Thrive Capital, or Kinnevik. Born and raised in Senegal, Valerie always had an entrepreneurial mindset and a specific understanding of emerging countries. So, Valerie, the fintech space is booming across the emerging world. Fintech companies have, this is my opinion, but I think it's probably true, have the potential to revolutionize finance, to reduce inequality, and to accelerate development in most emerging countries. What opportunities to achieve the sustainable development goals can these fintechs unlock? On the converse, if you want to, try it at the same time, what risks or potential abuses against human rights should be anticipated?
Cool. Thanks a lot, Eleanor. Thanks a lot for having me. Thank you. So my lens is very much from the operational fintech side for sure, but also I have very much of a lens that's kind of like Africa focused, so at least emerging countries focused. And I spent quite some time looking at this type of issues for small, young, emerging startups who are starting revolutionary concepts across Africa or elsewhere in emerging countries and don't even necessarily know what they're allowed to do and not allowed to do. And this is kind of like the basis of some of the problems that those fintech are looking at. And I think that, yes, the fintech space, especially in emerging countries, has a lot of potential to boost the sustainable development goals. And the reason why that is, it's because they allow to offer financial services to underbanked, to unbanked people, and also to offer them with a certain ease of use, but also at a very competitive price. So if we take, for example, the example of remittances. Remittances across emerging countries is a business that is generating tremendous amount of money to, I would say, old school players in a way, like Western Union and the likes. And those remittance companies for years have been covering crazy fees of like 10% and sometimes even more to send money abroad and to help the diaspora send money home. And today, finance companies are coming up with solutions to do that essentially for free. So if you think of it, it's like this is a huge empowerment for all emerging countries communities, whether Africa or also like Latin America is in the same case, Asia is in the same case as well. Like they all of a sudden, through mobile money, through easier financial services, have access to finances and have access to finances in a fair way and in a way that they feel that they can control. But at the same time, yes, there's a risk because there's no specific regulation. So all those companies, to be able to provide those services, end up collecting a lot of data. And the data that they collect is data that they use then to make the solutions even better or competitive or be able to sustain the services that they're giving to those population at an okay price. And of course, that this type of data is what we call big data. But big data is all sorts of personal data, all sorts of I'd say like sensitive data about people, and there are data protection laws internationally, but then they're not deployed in the right same equal way across the world. And it's very hard for also for populations who have just gotten access now to a lot of financial services digitally that they've never known before, to know exactly what to look for. So the risks are there. Also, I think it's the case for the emerging world, but it's also the case for more advanced economies. Because what fintech allows to do is that they also, the huge enabler in the lending processes. So we've seen even in the US, there's a wide range of companies that have launched over the past years that automates the lending process, and that allow to have like a much more automated, fast, efficient process for people who would not necessarily get loans or would struggle at getting a loan to get a loan in a matter of a few minutes. So of course, that's relying on a lot of data, but that's also relying on the fact that those companies are quite agile and can adapt their processes to specific cases in real time. But what it also means is that the downside of this is we might promote, whether in advanced economies or less advanced economies, and over debt rates I would say, and that is very tricky. And that's some of the things that we've seen in Africa happen, where, for example, in Kenya, you do have a lot of problems with people who have been offered microfinance loans by digital services that end up applying to annual interest rates that are completely crazy and that reach 100% of the loan. So that ends up being a massive issue in terms of repayments, and those people end up having debts for life. So I think that's one of the opportunities and risk at the same time that we can see in it. But I'm a big pro fintech, and I do believe that we're increasing people's lives. We're improving people's lives for sure. And I also do believe that we're helping a lot of the services out there to provide a better services to their users, and that essentially creates customer retention, which also is a huge opportunity not to overlook. Cool.
Okay, wonderful. Thank you, Valerie. I'm going to come back to you a little bit later for some of the the other side about that, the potential abuses, or if you're any practical examples that we can kind of talk about. But next, I would like to move on to our next panelist, Amit Sen. Welcome to the panel. Amit works at the UN High Commissioner for Refugees headquarters to address sexual exploitation and abuse in humanitarian settings worldwide. He previously served as UNHCR's Senior Regional Protection Officer for the Middle East and North Africa, where he coordinated protection from gender-based violence and child rights violations in conflict-affected states such as Syria, Iraq, Yemen, and Libya, among others. Before working in MENA, Amit was UNHCR's Regional Statelessness Officer for the Asia Pacific region, as well as a protection officer in Nepal. Welcome, Amit. Am I saying your name right?
You are saying my name right.
Okay.
We're
Okay,
more
wonderful.
than 90% there. But thank you so much. It's such a pleasure to be with you. And I wanted to note just very quickly that, yeah, I've been working with UN for some time, but I'm not really speaking on behalf of the UN right now, only because I wanted to draw on a broader set of experiences that also extend to doing asylum and refugee advocacy in the United States, in litigation, at the US Justice Department, and some other contexts as well.
Yes.
And I also want to confess that I'm somewhat new to this issue, and the opportunity to join this conversation is really an eye-opener for me. And I'm really excited by what I see as some potential to bring together a discourse between human rights practitioners and legal practitioners and technologists and design experts. And one of the things that it got me started thinking about is just design considerations in humanitarian practice. So Howard and I are partners in this project that he'll tell you more about. But one of the recent reflections that we had is that we have done some monitoring of how we deliver assistance. And just from a design perspective, what we found is that in the interest of trying to provide an inclusive, non-discriminatory, and egalitarian way of delivering assistance to people in crisis, we had physically assembled a single undifferentiated line that people stand in to get everything, all of their immediate necessities. When we started asking people about their experience in that line, the failure to differentiate was creating unanticipated problems. Women were not safe in that line. They had to congregate at the end. They had to wait longer. They may have gotten less. They may have gotten home later at night, faced accusations that they were out late. Maybe there's additional violence. For us, it's a learning point that we can have unintentional bias in design, and that can have cascading problems. And that's not even to mention all the other dimensions and axes of identity, sexual orientation, age, disability, and the like. With COVID, as everyone's very well familiar, that physical line is very quickly moving into the digital arena. And in fact, what's interesting is that there's a number of publications just now on how to do case management and indeed safety planning for survivors of gender-based violence over their mobile phone. And increasingly what we're seeing, research is telling us, but also just day-to-day interactions with people in crisis like refugees, stateless people, internally displaced people, conflict-affected people, is that they're using technology platforms to cope, to reconnect, and to survive. So there's a really interesting report called The Digital Lives of Refugees that look at the way that people in displacement in 3 countries use technology to meet day-to-day needs. And one of the findings is that private developed applications like Facebook or WhatsApp are really critical in allowing refugees to connect, interlocate, and reconnect with family, which of course has a rights base. There's a human right to family life and family unity. And here we have private sector developed applications, essentially in a way facilitating the enjoyment of that right. Mobile money is also incredibly important. But one of the realities for refugees especially, and for stateless people too, is that there's a very high level of being undocumented. There's a very high prevalence of being in a precarious legal status or being out of status. And that can be an inhibiting factor to registering for mobile money services, or in fact, for any other digital service. One of the other really big findings is that there are structural gaps around gender. So before we even get into humanitarian situations, humanitarian crises, in 75% of countries, men use the internet much more than women. And then when you look at refugee women, they're 47% less likely to own a mobile phone and even more less likely to access services, which is counterintuitive online, but it's true. One of the other findings is that if you just distribute tech, if you just distribute phones, you're not going to solve that problem because there are cascading needs. There's needs for data, there's needs for charging, there's needs for a protective, secure, and appropriate environment and experience online. I believe it was Isabel who referred to hate speech and incitement. Well, women have been found to experience, women and girls, violence, harassment, and threats 27 times more frequently than male users. So what this all brings us to broadly is that we have critical opportunities and tools that are largely private sector developed to allow people in crisis to negotiate and manage the pressures, the exigencies that they're under. But there's a problem. And fundamentally, one of those problems is that they've never really been at the table as stakeholders or as voices in the development of those tools, because they're often developed for, in a way, the most privileged user. And I just want to reflect really quickly, and perhaps if I may, say that I think Howard can fill in much better than me. I was reading the Secretary General's roadmap for digital cooperation, which I'm sure several people here are well familiar with. And one of the points that it really highlights is the need for digital literacy, not just hardware, not just investment, but literacy and support. And I want to perhaps just end with that, and maybe, if I may, because I'm kind of co-presenting with Howard, pass that question on, if that's really perhaps the issue, or is perhaps the issue a need also for ecosystem complexity, ecosystem simplicity, and experience equity. Thanks.
Thank you, Amit. You raised so many really interesting issues, and I hope that we'll be able to circle back to some of them directly. I'm going to move on to our next panelist, Howard Pyle. Howard, welcome to the stage. Howard has led digital transformation and design programs for both large global organizations and startups through his 20+ year career. In 2020, he founded ExperienceFutures.org, based on the idea that AI and machine learning can help create more equitable online experiences. Howard was previously Senior Vice President for Customer Experience Design at MetLife, a global function that included brand design, UX, digital marketing, sponsorship, and marketing technology. And I will say that I was introduced to or met virtually Howard and Amit through the Web Summit conference. So it brought us together, and I'm really thrilled to have you here. Welcome, Howard. My question for you is, well, if you have any response to what Amit was saying, that would be great too, but what has to change within organizations to ensure that AI, machine learning, and other innovations create more equity?
Thanks, and thank you for having me today and for including us. What an amazing conversation! What an amazing group of panelists. I think that the place that I would start with is I'm coming at this topic as somebody who has made digital experiences, digital platforms, products, applications. That's been my career. And I think that while I have been, I would like to think that I've been socially conscious and acting ethically in that capacity. I think the thing that I've come to realize is that the way that digital tools are made for individuals, especially in the private sector, is fundamentally built around the idea that the people who understand the way tools and applications and web experiences and mobile apps already work are the people that you're designing for, right? And another way to say that is that everything that you interact with that's built by the private sector is fundamentally designed for digital privilege. And I think that means to me that when I think about digital privilege, it's really the idea that if I'm making an app, a mobile app, that I expect a user to understand the way that it's organized because they use other similar apps, right? And what that means is that as you build digital tools, as you publish things, you expect users to be more and more and more digitally savvy, to have certain types of technologies. And there's many examples of this. In the US, one of the things that we see is, for example, for students, for households that make less than $30,000 a year, those students in those households, by and large, don't have access to laptop or desktop computers, which means they don't have access to financial aid. They don't have access to apply for colleges, right? So that's a design problem. One version of that problem is a classic digital divide problem. Well, we need to ship them a laptop then. Well, yes, maybe. But the other part of the problem is that the hundreds of different organizations who create applications, financial aid tools, education platforms that don't design with the idea that lower income users have different digital needs. And so that's one example. The thing that I've come to believe is that, and having both an engineering background and a product design background, is that we can begin to use machine learning and artificial intelligence in order to generate new web applications, new mobile apps, new types of designs customized to the needs of the individual. So organized so that the language is less jargon filled for an older audience, organized to be optimized for mobile so that people from lower income households can access them. People who don't have access to physical landlines or broadband, and how do they need to access these tools or information? And I think that we have this opportunity to recreate experiences for the needs of the individual. So that's the idea. The problem isn't a technical problem. The problem in the end, going back to your question, is really that organizations don't prioritize defining who their diverse users are. And they don't have the idea that they need to create different experiences or tools based on the needs of those users. There is a fiction within the technology community that there is the one application, the one website that should work for everyone. And that's the big thing that needs to change. So artificial intelligence and machine learning can help accelerate that problem, but fundamentally what has to change in innovation programs and product design groups is this idea that there is one solution that should work for everyone. So part of what Amit and I work on together is the ethics of that. How do you think about what are the ideal cases for the bar that a design organization or a digital organization or an innovation organization needs to be held to? And fundamentally, what we believe is that those are core human rights principles. And I think that, it's interesting, Pedro, to hear you talk, because one of the things that you talked about is new rights in the algorithm society. And I love that. That was a beautiful line. And I think that it's interesting because I think that to a certain degree, what happens when you rush digitization in the private sector specifically is that suddenly the social safety net that we believe that commercial capitalism should somehow support by going to a bank or going to a store or going to suddenly all that's online. And if those organizations are actually bad at making digital experiences, the social safety net, the access to society, the access to finance, the access to education go away, because those private sector organizations don't prioritize diverse users in the same way that they would to make sure that their bank branches accessible to people with disabilities. They just don't prioritize the same thing within digital spaces. So I think the thing that I'm personally most concerned about is making sure there's parity between the real world experiences that we've had within finance, government, the legal system, education, healthcare, and making sure that as that stuff is digitized, that people have the same abilities in their online space as they do in their offline space. And we're not there yet. In addition to that, we need to start thinking about new rights. And I think one of the things that I'm pushing my community on, the design community, the digital product community, the innovation community within the private sector, is we need to start thinking about who are you excluding by creating designs that expect people to be ideal digital users. And that has to change. That fundamentally has to change. So I do believe that technology, that AI and machine learning will fundamentally have an impact on that, but it starts with a mindset shift. So I think this community, the community that's thinking about sustainability, the community that's thinking about human rights, the community that's thinking about how do we move into more ethical spaces, needs to help the digital makers set the bar for the experiences that they're creating. And that can be assisted by technology, but it's not ultimately a technology solution. So that's kind of where I would pause.
Perfect. Thank you, Howard. A lot of powerful statements that you made there, and I think a call to action in there as well. I love the shift that we sort of started broad. We started with Isabel defining terms and speaking kind of generally, and I'd like to dig in a little bit more, dig into some specifics, some practicalities. So first, I'm going to turn to David and then Pedro to ask David first. Do you have any examples of human rights due diligence under US law, or any thoughts? We're in the ideas phase, right? So any thoughts as to how best to approach this issue with respect to US domiciled businesses?
Yeah, it's a great question. And the answer, I would say surprisingly is yes, to some degree. Again, speaking as a business and as a securities lawyer, I think of, there's a famous quote by a United States Supreme Court justice from the 20s and 30s, which happens to be the time when the New Deal took shape in the United States. And that's Justice Brandeis, which is sunlight is the best disinfectant. Whether or not he actually wrote that or not is something of historical note, but he's certainly credited with it. And in that regard, the architecture of the federal securities laws in the United States is such that if you want to list your shares on a public stock exchange, NASDAQ, New York Stock Exchange, whatever, of course, you have to register your shares, and there's an elaborate process for that. After being so registered, there is a continuing disclosure regime, and the basic structure of the federal securities laws at the highest level is creating a system of informed investors through disclosure, and therefore creating stable capital markets. So it's the disclosure regime that's relevant here, and there is some history of requiring disclosure by publicly traded companies of information that is not only of importance to the success, profitability, and so forth of the business enterprise itself, but also to the community in which the business operates. And so the most recent example of this is the conflict minerals issue. So during the Obama administration and in the wake of the global financial crisis, Congress passed the Wall Street Reform Act, more commonly known as the Dodd-Frank Act. And Dodd-Frank had one provision in it that said, at a high level, do you, as a publicly traded company, use conflict minerals? Conflict minerals being a defined term, tin, tungsten, gold, tantalum, are the metals that are used to a very large degree as key components in electronic devices. Your iPhone has them, for example. And conflict minerals are the sources, the derivatives of these conflict minerals are the sources for key metals that are used in the development of electronic products. Why do we care about that? Well, because a key source of those source minerals are nations surrounding the Democratic Republic of the Congo. So there's about 10, I think it's 9 or 10, it's the Democratic Republic of Congo and 9 or 10 countries around it. And the issue as flagged by the UN is that there is mining of these key technical minerals by armed groups that foment conflict and therefore create an ongoing humanitarian crisis. So cutting to the chase, what Dodd-Frank did was say, look, hey, are you using conflict minerals in the development of your products? If yes, then you have to do an investigation, due diligence, to use our verbiage, to see whether or not your source of these conflict minerals is from one of the covered countries, one of the 9 or 10. If it is, or possibly is, the keyword is may, if you may have sourced from a covered country, then you have to produce what's called a conflict minerals report. And the key to all this is that has to be publicly filed. So if you want to know anything about a publicly traded company in the United States, you just go to the Securities and Exchange website. The search engine is called Edgar, EDGAR. You do an Edgar search, type in the company name, and you want to see every public filing by Apple, Microsoft, whoever. You just go to Edgar and you can pull it up, and there it is. And sure enough, there's a form called the Form SD, Sam David, that deals with conflict minerals disclosure. So there is some precedent for this. It exists. There's sort of a good news, bad news, good news on the conflict minerals issue. Good news is there's such a rule. It passed. It got through the United States Congress. It was rules were promulgated by the SEC. Companies complied, and the reports. If you look at Form SDs, I pulled a few up before this panel. They're very long and they're extraordinarily detailed on sources of smelters and places where they've gotten their source minerals. The bad news is it immediately drew a constitutional challenge. So there's been litigation over this, in particular one aspect of the rule. The rule failed as a constitutional matter. The issue in brief is free speech not only means in the United States the right to say what you want, it also means the right to not being told what to say. And so part of the rule failed on a compelled speech basis. And so I would say overall, the conflict minerals disclosure regime is somewhat in flux. So that's sort of the good news. There's a rule. Bad news, drew an immediate constitutional challenge, and part of the rule failed and crumbled. But here's the good news at the end. Notwithstanding that the rule is somewhat in stasis and somewhat in enforcement limbo if you don't do the disclosure, guess what? Go to the 2021 Form SD filings and you will see companies are still pretty much complying and filing the reports. And adding to that, if you sort of read the literature, it appears to have had some effect, in terms of, companies don't want to disclose that they are receiving their minerals from armed groups, which is also a defined term. So there's one example for you of how it's had some effect in the United States.
Perfect. Exactly what I wanted. Pedro, I'm going to turn to you and ask a similar question. From a practical perspective, what are specific strategies that companies can use to mitigate the risks posed by digital technologies? And I will say, I'm going to interject a little here that, we'd spoken a little bit about privacy before. I don't know if you want to talk about that at all, but if you can, that would be great.
Sure.
Thanks.
I guess the first advice is always not to play smart. It's always a bad thing to play smart, think that you're much better than the laws or the regulators. I want to say first, three things. I think in the beginning of the internet, we had three fundamental illusions. We had the illusion that the internet was the same place for everybody. That's not true. Clearly not true. We had the illusion that the internet, the digital world, was some kind of new liberated world. That's not true. There are immense power relations in the internet. We know this. Many of the panelists already spoke about this. And thirdly, we had the idea, the illusion that the internet was this, dominated by individuals interacting among themselves. That's not really true. Just talked about the emergence of digital platforms and new public powers, new private powers. So that's not really true about this. The three illusions, I think, have succumbed particularly in the last decades. So to come back to your questions, what do we do? Assuming that we operate in a digital context with digital players, with digital companies, what do we exactly do? There are things we do, and they are very clear. We can very clearly ask a bank whether that bank really, as Howard was mentioning, that bank respects the right to explanation in terms of how artificial intelligence algorithms process their clients' information. We can actually see whether an insurance company, respects the health data of their clients. We can actually ask and check and identify whether a digital media company performing targeted advertising really identifies the advertisement, really respects advertisement laws, particularly in Portugal, which makes it necessary to identify an advertisement as an advertisement and to be transparent. So we can actually ask, check, verify, identify whether a services company is really compliant with the right of employees, for example, to the portability of their data, let's say. So these are very practical questions we can ask, and we can actually identify and check, and we do it. We should do it. And by the way, I work in a law firm, and others do it with respect to ourselves. So we're in this context, interrelational context, where the kind of practices we use are practices the others also do with respect to us. So it's really something we can do in practice. Of course, there are other cases where things can be more complex, and where I would say it's not easy to check. Well, did this company actually respected privacy laws or specific rights, or is this company really, or is this company fully respecting the freedom of expression of their employees, for example? So what does that mean? Freedom of expression of employees. Is it possible that an employee uses social media to criticize the company? So just to give you a very classical example of a conflict between the employee's freedom of expression and the company's right to, let's say, reputation or other economic rights. In those type of cases, this is the due diligence and the assessment is much more difficult, because there are balances here involved, and we often tend to forget. Nowadays there's this new trend about digital constitutionalism. I hear it all the time. It's clearly a new word coming from the academia, coming from the political world, the need to enforce constitutional norms in the technological digital world. And I'm okay with that. Provided that we understand that in many cases, we need balances. So constitutionalism is not only about ensuring the rights of a certain group or certain groups, it's about establishing the appropriate balances, the balances between companies and employees, the balances between the right balances between financial institutions and their clients, the right balances between the media companies and their readers, their users. Balances are needed. Balances will be increasingly needed to arbitrate this kind of conflict. And I think that's where we will need additional work. We will need lawyers, by the way, because at least in principle, we're supposed to exercise judgment in a proper way. I'm not sure if that's always the case, but at least we have that reputation, and we should protect that reputation, and we should safeguard that reputation. But we actually should and need to define what are the appropriate balances in those complicated cases. But to sum up, yes, in practices, these are the examples, very concrete questions that we can plausibly ask, and we do it, and we ask, and we ask for information, and we check that information for sure.
Wonderful. Thank you, Pedro. That's exactly what I was looking for. We have some, I don't know if you've noticed, we have some questions that are coming in fast and furious in the chat and the Q&A box. Valerie, I'm going to turn to you before circling back to Howard and Amit, but if there's anything else, you spoke about opportunities, and I'm just wondering, first of all, there was one question in the chat. I'm going to leave it to you as to whether or not you want to answer it, but there's a question about, oh, I just lost the question. Oh, here, can the digital platforms help protect human rights defenders that become globally exposed? So Valerie, you can either answer that or the follow up on the question that you were speaking about earlier about opportunities that are posed by these platforms and or problems, opportunities towards meeting the sustainable development goals or problems, or you can answer that question or any of the other questions in the chat. Okay.
Sounds good. Thanks a lot. I don't know if I'm the best person to answer the question, but I would say that, if you look at what digital platforms could do, yes, of course, there's a business case that could be made for doing this and for achieving that and digitalizing the process. I'm not sure who would have a full answer to the question, or if I understood it properly, but I would say yes, of course. I mean, as long as there's a business case to do so, and like a digital experience case to do so, that would be doable. Like a company could do that, or it could be essentially also institutions using digital services or applications to do so. I would assume. Yeah. On the different opportunities and risks, I think we went through a few of the cases before. I would say one of the things as well that it kind of made me think about answering, hearing all the different comments is companies can do things, but also institutions eventually could do something about it, especially in the emerging world, and potentially could help mitigate some of the challenges that we're facing, especially in the fintech space. I would say also investors. So we, as fintech companies, as tech companies as a whole, all the investments that are flowing into those industries comes from private VC investors, and they're funding those companies millions and millions of dollars every day for them to really grow at scale. And I think one thought that could be interesting to play around with is they know the risks when they invest into those companies. They are completely aware of the benefits. They are aware that the benefits can also generate some substantial revenues and increase the valuations of the companies that they're putting their money in. But they are aware of the risks. So one thought we could play around with a little bit is how could we eventually think about, somehow human rights due diligence that they could also run, or could they be incentivized by doing so? So like there's a lot of those funds, for example, that do focus on impact. And a lot of the impact funds that we're seeing more and more have some impact goals when it comes to how they manage their portfolio and what are the companies that they actually invest in. I would assume that we could see something similar being done for the human rights. I'm not the expert on like how we could do this, but I guess that's something that we could see that could happen, that could kind of solve that question. Yeah.
Okay, great, thanks. Amit or Howard, do you have any responses or anything that you would like to say in response to anything that's been said before? I see that people are responding to questions in the chat, but if you want to respond live to you.
I wanted to respond a bit to Pedro, but also Howard, about this idea of new rights in an algorithmic space. I think it's maybe a new look on and a new lens on well-established rights. So one of the rights that I think a lot about and that I was trying to get to is the right to participation. So we think about the CEDAW Convention 1979, talking about women's rights to cultural life, to development, to public and political life. We're very familiar. One of the founding principles of the Convention on the Rights of the Child is the right to participate and be heard. But that was thought of more in terms of judicial and administrative proceedings. And of course, the Convention on the Rights of Persons with Disabilities, a more recent instrument, but one that talks about participating fully, or the right to participate fully in, quote, all aspects of life. I think it's fair to say that even when these instruments were written, some going back to the 70s and the 80s, that they weren't talking about digital equity. That in practical terms, to participate now fully in all aspects of life, public life, cultural life, political life, development, administrative, judicial, it requires the right to participation in digital life. And that participation, what I was trying to get to, comes back to this principle that we need to be listening to, consulting with, and partnering with more unconventional users, a broader and more diverse set of users, and really engaging with them in the design process, especially with user experience, front-end experience, if we're going to meaningfully deliver on this promise of digital equity. And I may defer to others to complement, because again, I'm not as literate in the technical space at all. Thanks.
Okay, thanks, Amit. Do you have a response to this first question, or that's in the Q&A? Can the digital platform...
Was it on risks for refugees? I
No.
tried to answer it in text. Sorry.
Can the digital platforms help protect human rights defenders that become globally exposed?
Yeah, maybe if I can just touch on that really quickly. I wouldn't purport to understand how it could protect them, because it's just not my area of expertise. I am aware that a lot of people who are refugees are human rights defenders, and that's why they're refugees. And one of the risks that has been documented, particularly for women and girls, and particularly for LGBTQI+ people, is immensely escalated threats of violence, harassment, disinformation, misinformation. And what can happen, and has been seen to happen, is that for safety and for coping purposes, people retreat off of digital space. And that re-entrenches the hierarchy, that re-entrenches the privilege, the asymmetry. So not only vulnerable people, but vulnerable people who may be human rights defenders aren't necessarily safe. And I think that goes in part to experience, and potentially to experience, equity. So what can be done to make those environments safer? What processes of consultation and collaboration with people with those backgrounds and experiences need to take place, perhaps aren't taking place, to make those digital environments more salutary, more rights respectful? Thanks.
If I could interject, I think one of the things that that's interesting here is that, and Valerie, I think, touched on this a little bit, which is this question of what is the incentive for corporations who make digital tools to build in these protections, right? And I think to a certain degree, and I've seen this in my career, it's big companies who make digital tools that end up getting used for human rights, or by, underprivileged individuals, whatever flavor you want to look at, they will, I mean, it's going to be very cynical for a second. They will look at the places where it helps people and use it in their marketing materials. And they will ignore the places where it actually disadvantages people unless it has a financial impact. And so I think one of the things, just to be very candid about it, that has to happen is there has to become financial impact to organizations when their tools and their platforms are used in ways that put people at risk, that put people in harm's way, that accelerate, social inequity. And I think some of that is going to have to come from consumer rebellion, but some of it's going to have to come from regulation. Some of it's going to have to come from, if you look at things like the GDPR around data privacy, what if we were to have a similar set of regulations around what happens to organizations that work across international borders with platforms that actually have a negative impact on human rights? Big companies are not going to pay attention to this stuff unless there's a financial incentive or unless there's a risk. And if we can't bring them the financial incentive, we need to bring them the risk.
Okay, thank you. Thank
you. Including reputation risks, right?
That's right. I agree. Yeah, that's right.
Thank you, Howard. David, there's a question directed to you in the Q&A that you said that you will answer live. You talked about the Dodd-Frank Act and public disclosure of information in relation to conflict minerals. Do you think that this type of requirement could be replicated in relation to human rights risks in new technology? And before you answer, I'll just say to everyone that the panelists that after David's question, everyone will have space for a 1 to 2 minute kind of concluding remarks about hope, opportunity for final reflections. Okay, thank you, David, the floor is yours.
Excellent question, and something actually I've wondered about myself quite a bit. There's no doubt in my mind, and I think the data show it, that the disclosure regime of the federal securities laws is a powerful tool for shedding sunlight on how businesses operate and what their financials are. The question behind your question is really one that's been debated, which is what disclosure is appropriate. What are the federal securities laws for, after all? I mean, certainly they're designed to ensure the stability of capital markets and information about the profits, the financials, the business operations, and so forth of a business are all sort of fundamental and not really debated to a large degree. But to what extent do you extend those disclosure obligations to other things, to, again, everything we're talking about here, which is the risks to others, the risk to the community in which the business operates? And frankly, there's kind of two views on it. And one is, look, we may oppose this human rights violation, but that's not what the SEC does. That's not its charter. That's sort of one view, and that's come out of the SEC itself. The other view is, look, listed companies are corporate citizens. They're part of the global community, and these things are important, and they bear on one's investment decision, and they bear on the stability of capital markets, and therefore this sort of thing is inappropriate disclosure. So I think the short, cutting to the chase, the answer to the question is yes, it can be replicated. It can be extended to other aspects of human rights. The trick will be to thoughtfully and carefully attack the problem, write the rules such that they pass constitutional muster in the United States. Just, forced speech is the issue. Compelled speech is the moniker as a constitutional matter. There are limits on what you can compel anybody, including corporate citizens, to say. And so, as ultimately Congress and the SEC, would they be so chartered, would think about these things, they would have to consider it with that within that framework. So, but excellent
Okay.
question.
Thank you. Thank you. David, do you have a final statement, or is there something that you want
I would
to
just say I would just wrap by saying this was an excellent discussion. Really good points all around. And I would just sign off with that.
Great. Pedro, final remarks, opportunities, anything you'd like to say?
Final remarks. Well, I would say that, this is obviously a very interesting, fascinating discussion, but it's actually several discussions at the same time, because we, on the one hand, we may ask, how digital companies, particularly in the tech world, incorporate human rights, fundamental rights standards. How actually do they incorporate in their commercial practice these new rights, not only traditional rights but also new rights. Also, another questions, on the other hand, how the digital companies, technologies, technologists as well, design their products in a way that support digital literacy, digital inclusion. Totally agree with the idea that digital inclusion is a fundamental aspect. I've just been working, by the way, in a project in Africa regarding public access to internet. Fascinating project. And it's not only an African matter, of course. Portugal, where I live, it's completely has a serious problem of digital inclusion, by the way. So this is a separate topic. It's clearly a separate topic, obviously a interrelated topic, but it's also, and finally, how the internet overall can be designed, defined, structured. How can we design an infrastructure that really balances the rights of individuals as digital actors, corporations also as digital actors, and the rights of citizens? How do these worlds actually are balanced, and because they often clash, and how do we actually do these kind of judgments and these kind of balances? I think this is I think these are just I think this is a research agenda, also a political agenda, a legal agenda, and certainly the conversation will continue for sure. Thanks.
Absolutely. This is if anyone is in the audience listening and wants to take this on, definitely. Valerie, your turn. Final remarks.
Yeah, I mean, it's been really great to be part of the conversation, especially that my area of expertise is more like, of course, on the application side and less on the legislation side. And to have everybody's perspective on it from a legislation point of view is really eye-opening and encouraging as well, that like people are looking at those issues and trying to find solutions. One remark is, I mean, if I think about fintech and I think about emerging world and tech as a whole, I think all those opportunities are there. They keep on increasing. There's more and more teams and companies and people coming together to tackle those opportunities and come up with solutions. And the more solutions we come up with, the more risk we're going to end up finding for human rights. And definitely, I mean, I think that none of the people behind those technologies is badly intentioned. I think that it is true that sometimes, you have in many places, many countries, or people who develop applications without even knowing the extent of the risk that it has for human rights. And I think that, yes, there's a lack of legislation in this area. There's a lack of support from maybe other organizations. And clearly the incentive point, I think, before there is an incentive for everyone to actually solve the problem, I think it might take time. But I think I also agree. I think this conversation is fascinating, and I think it's the beginning of of many others around the areas, and the more there is, and the more awareness is being raised. So I think it's great, and I thank you very much, Eleanor, for having us.
Wonderful, thank you. Amit, final remarks.
Yeah, thanks so much. This has been such an enriching panel, and I've learned so much from everyone here. So first of all, huge thanks. But I wanted to confess that before I kind of came to this conversation or started talking with Howard at ExperienceFutures, I had a very narrow view of digital tools and digital experiences as simply a conduit for services for populations I'm working with. And the more I started looking at this issue, the more I realized that it's really an arena in which people cope, survive, and sometimes thrive, reconnect. But it's also a place where human rights can become imperiled and in fact can be violated. So I think there does need to be much more attention drawn to promoting the enjoyment of human rights in digital environments, especially because I think the line and the boundary between our lives offline and our lives online is more and more tenuous. And having an 11-year-old, I can tell you that I think younger people, but many people, really increasingly live online. And I think the other thing, just really quickly, is that I think there's a lot of attention to the digital divide in terms of who has access to hardware or who has access to broadband. But I'd really like to be looking more and thinking more about experience equity in terms of what is the nature of that experience. Because very briefly, what we've seen is that for huge categories of very vulnerable people, it's not sufficiently safe, it's not sufficiently tailored to their needs, their identities, their specificities, whether that's women and girls, people in crisis, LGBTI people, people with disabilities, others. Thank you.
Wonderful, thank you. Howard, you have the floor.
Thank you so much, and thanks for including me. This is really such an amazing event. I think I learned a lot today, and I think one of the things that strikes me is, that this conversation around human rights in digital spaces is, my experience is often seen as someone else's problem or a part-time problem by the people who make digital tools or solutions or platforms. And I think that conversations like this are important to bridge it together. I think one of the things that the legal community can do is help digital publishers understand the risks. That seems to be like one of the core things that lawyers are really good at is here's the risks, here's the challenges you face. And I think that's both commercial risks, regulation risks, but also societal risks. And I don't think that digital publishers have a good sense of those risks. And I think too often they're driven solely by the opportunity. And I think that conversation needs to be twofold, right? And so one of the things that we try to do when we go into partner organizations is help them understand where the risks are in their digital tools and platforms, but obviously where they can grow or expand and what the new markets or new opportunities are. Honestly, I feel like the big motivator right now is going to be the risk side. So I think this community has a huge role to play in the private sector and digital publishers, helping them understand that. So thank you.
Thank you, Howard. Before I turn it over to Shen, I'm going to turn the floor to Claire. And I'll just say that I agree. This is the beginning of a conversation. And I hope that we'll be able to have many such conversations in the future. Claire, please take the floor.
Thank you so much, Eleanor. I'll be very brief. First of all, I wanted to thank all the speakers for this fantastic, very insightful discussions. And thank you also, Eleanor, for the wonderful sharing. I just wanted to end on one note, which is linked to what Howard was saying when you were talking about the GDPR and the need maybe to have a sort of GDPR in the field of human rights. And maybe an optimist note, this is coming at the European level. We have a commitment from the European Commissioner for Justice, Didier Reynders, that a legislative proposal requiring companies to exercise human rights due diligence will be tabled in the coming weeks. In fact, Didier Reynders delivered a video message earlier at the opening of this conference, and he confirmed that this coming directive will apply not only to EU-based companies, but also to non-EU-based companies doing business in the EU. And of course, digital companies will be part of the scope. So they will have to undertake human rights due diligence. What does it mean? They will have to identify what the adverse impacts on the human rights are and address them in light with what Isabel was saying at the very beginning. So regulatory changes coming in the EU, but it will have implications way beyond the EU. And with that, I will finish here and pass and the floor back to Shen for the closing.
Thank you. I hope that all of you have found this section as informative as I have. Again, I'd like to thank our chair, Eleanor, for her excellent moderation of the panel and for all of her work organizing this panel, together with myself and Rafaela Oliveira, as well as our excellent panelists for their very insightful interventions, and of course, the audience for joining us today. You are more than welcome to join us for the next panel of this conference, which will take place tomorrow from 10 to 1 p.m. Lisbon time. The topic is decent work and migrant workers. Finally, before you go, if you enjoyed today's panel, we would like to invite you to follow NOVA BHRE on social media, listen to our podcast, and sign up for our newsletter. Thank you for your participation. It has been a great honor and a pleasure. Until next time,